Hello and welcome to this webinar on advising later life clients about estate planning. My name is Anna Pollins, I'm Head of Strategic Partnerships at Octopus Investments, and we're joined by Tish Hanifan from the Society of Later Life Advisors today. We're going to be answering lots of your questions on the topic around advising later life clients, as I say, about tax and estate planning, and trying to address some of the common questions that you will have, especially around balancing, for example, the cost of care and some of the new sort of legislation changes as well that have come in when it comes to inheritance tax planning in particular. Just a really quick refresher about Octopus Investments first. For those of you that don't know us, we're the market leader in tax efficient investments, but probably the most relevant here is that we're the leader in BPR qualifying investments for inheritance tax planning. We spend a lot of our time at Octopus helping advisors, doing lots of training, CPD events, lots of resources, which I'm going to signpost at the end of this webinar too. But as part of that work, we've partnered with SOLLA, the Society of Later Life Advisors, because we think the work they do is incredibly important, and we do lots of joint training with them. And that's why I've got Tish here today. You've sent in some great questions. Thank you for doing that, which we'll, as I say, try to address throughout this webinar. And if we can't answer all of them, or if other questions do come up, please do send them through to us afterwards, and we'll be delighted to answer them for you. So quickly just introduce Tish here today. Tish is a barrister and founder and joint chairman of the Society of Later Life Advisors. But not only that, she's also vice chair of STEP in her spare time in Kent, and a founder member and head of business development at the Solicitors for the Elderly. She works extensively in the areas of policy development, financial, legal training and advice delivery in relation to older people. That's involved in the delivery of national standard setting and accreditation for financial and legal advisors in the older client sector. And that's just in her spare time, amongst everything else that she does. So before we start, we are going to be talking about business property relief investments. So I did just want to highlight a few risks to BPR and those investments. It is really important. As I say, it's not the focus of today's session, but BPR is going to come up, and we will probably be talking about it at the end as well. So I did want to highlight that to you. So first things first, as you'll be aware as financial advisors, the value of any investment and the income from it can fall as well as rise. So investors might not get back the full amount that they invested. Tax treatment always depends, of course, on the individual circumstances and could change in the future. And the relief will depend on the portfolio companies, so the underlying investments that we have maintaining their qualifying status. When you're investing in business property relief investments, they are smaller companies, so unlisted companies or smaller companies. So they're going to rise and fall in value potentially more than shares listed on the main market, so the London Stock Exchange as well. So it is really important for people to be aware of that. They might be harder to sell. So I just wanted to highlight that to you. They're not going to be suitable for everybody. So, the recommendation should be relevant to the individual client circumstances. You're going to have to take a holistic view of their situation and objectives and needs, of course. And I guess part of our job at Octopus is to really help you identify the types of clients where it could be relevant. And as I say, hopefully some of the support we provide, talk about today, and in some of the other training we offer can help you do that. So once we've got that exciting bit done, I just wanted to welcome Tish. Thank you for coming along today.
Thank you for inviting me.
Excellent. So we've had lots of questions through.
Okay.
A question we often receive from advisors is around how do you manage do IHT planning when there's a power of attorney in place? And I think there's probably a few questions there to ask you. Firstly, probably to sort of start by asking a more general question about power of attorney and what you would expect an advisor to do when, if there isn't an LPA in place, what should their sort of responsibilities be with that, and then some of the practicalities to consider as well when there is a power of attorney in place.
I think that is actually a huge question. You're absolutely
I
right. Starting with that first point about if there isn't an LPA in place. If there isn't an LPA in place, you can't make a client have one. But that doesn't mean that you don't have the responsibility to try and persuade them that they should have one and to give them the advice that's good for them, which is realistically they should have an LPA.
Yeah.
So I was actually doing some work about this recently and looking at why the public, why the consumer doesn't have an LPA. And interestingly, the numbers that do have them is going up. So last year, 720,000 people registered LPAs. So that's good news. The reason people don't have them is sometimes a bit of a misunderstanding, because they think that because you have to register an LPA in order for it to work, if they haven't had some good advice from, for example, a financial advisor about how they work, they tend to think all about losing control.
Yeah.
Having an LPA requires you to think about what you personally no longer be able to make decisions for yourself. That's not a good thing to think about. And it also makes you think about that losing control. And a good thing for advisors to do is to remind someone that if they do have an LPA, then actually what they're doing is they're retaining some element of control. Because if they lose capacity, if they can't make a decision, someone will have to make a decision for them. They have this legal maxim, which basically, I won't do the Latin bit for you, but it translates into the law abhors a vacuum. What that means is if someone can't do something, someone else will have to fill that gap. So there will have to be a deputy appointed, and there's a long discussion over whether you should have a deputies or attorneys. But the great point about an attorney is that you have chosen them. So it's really important for advisors to talk effectively to their clients and persuade them that it would be a really good idea to have one. If they don't want to have one or they put it off, the advisor at least has covered that risk. I think that's really important. But I think there is also an element where it would become difficult, in the long term, it may become difficult for an advisor to work with that client if they don't have a power of attorney in place, if they lose capacity. I mean, for example, you mentioned pension freedoms earlier on. Great, there's lots of things happening with pension freedoms, but where people are going to go into drawdown arrangements, I would go as far as to say it's not at all good for an advisor to be entering into those arrangements with clients, which is all about saying, you're going to be coming back again and again and again, without asking them about what happens if you can't make those decisions about withdrawals. So there's a whole lot of areas for later life advice where it's good for the client to have them, which is the most important thing, but it also makes the advisor's job so much easier.
Yeah. I mean, I sort of see, if you have a will in place, that takes care of your estate once you've passed away, and what happens to your estate and sort of all your wishes. But the LPA is what happens whilst you're still alive, and actually is in some ways more important.
It is really important. It means that you retain some degree of control because you've chosen the people. It's also really important to remember that, as I said earlier, LPAs aren't either or. So once you register an LPA, you can say in an LPA that you don't want that person to make decisions until you lose capacity. Yeah. So it's an insurance against you losing the capacity. It's not a giving up of that. And that's really helpful because a lot of people have LPAs and it isn't always about losing mental capacity either. Sometimes with people, older people, it's about physically just not being able to do it. They don't want to be able to go. They can't. They're perhaps tired, or they've got some physical disability that they don't physically want to be getting out and about to make these decisions, to see their bank manager, for example. Yeah. So it isn't always that it's because you lack mental capacity to make decisions that an LPA is very useful.
I think that's often a common misconception.
Yeah, it is, I think so, yeah.
That there's a power of attorney in place, therefore you yourself can't make a decision as well. Yes. Or that the person, if an advisor, for example, is working with an attorney, that the donor can't also be involved in that decision.
That's a really, really good point. So anyway, if someone's got a power of attorney, if I had a power of attorney in place with you, of course you would be my ideal choice. If I had a power of attorney in place with you, that would mean that if you could make decisions for me, if I haven't put a restriction in that says only if I lose capacity. But it doesn't mean that I still can't go on making those decisions. But if, for example, I was temporarily incapacitated, like I broke my leg or something, in that time you would have that power of attorney to act for me on my behalf. So it doesn't wipe my ability to make decisions out, but it does facilitate having someone act for you. And I do think that is one of the reasons why people misunderstand it and are therefore a bit reluctant to do it.
How often do you think clients and potentially therefore advisors should raise this, should review the LPA that's in place?
I wouldn't want to put a temporal time on it, like every year, every 6 months, but I do think one of the things that drives good financial advice is reacting to life events.
Yes, good point.
And so and that's true whether it's legal or financial, when you're seeing someone and you're doing a quick review of how their circumstances have changed, that may well be a good time to look at the LPA. So, for example, if someone had become widowed, the chances are that their spouse was the power of attorney. They might have been the only one, for all you know. So that's a good time. When people are talking through issues around family, if you have the right soft skills, to draw people out that they can tell you things that sometimes it's quite hard to tell, but you need to know. Things like changes in family dynamics.
Yes.
If that comes up in that wouldn't be a bad idea to say then, just in passing, just to go back, your power of attorney, are these people, are they attorneys? Because that may prompt them. Quite often, people actually forget. If they've done one in advance, which is very sensible, they might not have really put the two events together.
Yeah. When it comes to inheritance tax planning, that's quite a hot topic when you combine, a hot topic anyway, and then when you combine when a power of attorney is in place. And there's probably a few questions that come up quite regularly, so I'll try and break them down. I think one of the questions we often get is how restricted can you be, or what are the restrictions when it comes to inheritance tax planning where a power of attorney is in place? And I suppose the answer depends somewhat on whether the donor has mental capacity or doesn't have mental capacity. If they do, I presume that's quite a straightforward answer, but where they don't have mental capacity, what are the sort of restrictions that typically apply, and how do you manage that?
I think you're right. If you've given someone if you've done a lasting power of attorney and you retain capacity, you will always be the person that can make the decision. In any event, anyone who is acting as an attorney is acting under the principles of the Mental Capacity Act, and there's guidance in that. And there's, without quoting lots of sections, most financial advisors and solicitors in this area are very familiar with Section 4 of the Mental Capacity Act, which is about attorneys always acting in the best interests of the person who's given them the power, the donor. So the best way to find out what's in someone's best interest, ideally, is to ask them. So that's why, even if someone is acting for you, if you have capacity, they will try and ascertain that from you. If you don't have capacity, they will look at they might look at instructions you've given. The LPA might contain some, and that often comes up to things such as gifting. So, for example, in a power of attorney, you might have put in some restriction as to gifting, or you might have put in, because the LPA is a standard document, but you can tailor-make it to your own requirements. So there's the opportunity in there. You might have put some things in as guidance to the attorneys of what you want to do. So the attorneys using the lasting power of attorney are always going to be looking at what's in this person's best interest. The difficulty that arises, I think, with powers of attorney and estate planning, prima facie, is that if you look at estate planning is actually about protecting the estate.
Yes.
It's not necessarily about protecting the older person, the donor, for example. So there would be one way to view it, which would be that giving someone's assets to someone else, how can that be in their best interest? And that's always the dilemma that arises with IHT planning. However, that doesn't mean that. So then if you look at that, quite often what happens with advisors is they will then start to think, well, does that mean that you can't do inheritance tax planning? And the answer to that is no, because although there is a power of attorney, everything is always subject as well to the Court of Protection and to the administrative part, the OPG, the Office of the Public Guardian, who can give a lot of guidance on this. It's always open to the attorney to apply to the court for an order for inheritance tax. So the court will then look at it, and they look really closely at the individual situation. They'll look. There was a very interesting case recently which involved the agreement to transfer, I think it was 6 £6 million. It was just a few months ago, from an older person's estate. In fact, the gift was an IHT planning into Vivus gifting, so it was going to gift it to someone. And the person was going to be, the attorney. And the court did allow that. So that might be quite extreme. In that case, I have to say the woman had a very big estate and everything else was well managed. But it was an interesting example of, yes, you can make lifetime gifts. Yes, the court will authorise them if they feel that it represents the interests of the older person and the older person's ongoing lifestyle has been protected. And no, it doesn't necessarily mean that a gift can't be made to attorney themselves. So the answer is, you can't, you're limited by law of what you can do as an attorney with a gift. So giving gifts on behalf of the donor is limited by law. There's a part of the Mental Capacity Act that specifies small gifts on certain occasions, such as weddings and birthdays and things. Anything else would have to have the court's approval. But that's a formality in the process. It's not a barrier to you can't do it. And realistically, if you're doing the right kind of inheritance tax planning, and it is actually right for your client, the court will approve it. If the court don't approve it, it's a way of looking back and saying, well, really, were we doing the right thing?
So a question that we often get at Octopus, or we see a lot at Octopus, about 20% of the cases we see into our inheritance tax service, which is into a BPR qualifying investments, is where there's a power of attorney in place. Now, that doesn't mean that in all those cases the donor has lost mental capacity. No. We don't know. But in many of those cases, the attorney is clearly acting on behalf of the donor, and the advisor is working with the attorney and hopefully the donor as well. I don't know if that surprises you, but we do often get this question. We work with a lot of solicitors as well who recognise that business property relief as an investment can work for inheritance tax planning where there's a power of attorney in place. What are your views on that?
I agree it can work. Yeah. I think, and when you always ask about risks, ultimately the donor, the person, the client themselves is always the client. The risk in that sense is very much as well to the attorney that they have satisfied themselves that this is an estate, a person whose financial position would benefit from high risk investments, high risk products, and that's where a good financial advisor can come in, because one of the roles of a financial advisor, which should help an attorney to feel satisfied they've carried out their role effectively, is to cover that off with the attorney in exactly the same way they would do with an older person that had capacity, which is exactly the same way as the FCA would ask you to do, which is looking at attitude to risk, capacity for risk, always with the provision with older people that you don't have so much time to put things right. But equally, one of the things with older people that is an issue is that they quite often don't do inheritance tax planning till a lot later than they actually should do. And there is a time advantage in terms of these kinds of products that of 2 years rather than say 7 years. So that you'd have to weigh that into factor. So I don't think I think LPAs can be used with to do BPR planning. I just think that they would have to cover off very clearly had the right kind of advice. Having said that, product providers such as people that offer these, in my dealings with all of them, yourselves included, are very careful to ensure that they've had the right kind of advice before they would let them proceed with that product anyway.
Yeah. And you're absolutely right, financial advice is so key when it comes to all forms of inheritance tax planning. Another question that comes up quite a lot in relation to power of attorney, and I think, so the Law Society has always had some guidance in their guidance notes around when you're drafting an LPA, the importance actually if you want to delegate to a discretionary fund manager.
Oh yes.
Another hot topic.
It's a very hot topic.
And that's always been the guidance for a long time, I think, from the Law Society, that actually, the ability to delegate to a discretionary fund manager when there's a donor, if you want to delegate their investments. And I think, but more recently, in the last couple of years, I think there's been further confusion in that the guidance notes that came out, I think, from the Public Guardian, I think, said, the importance of, they suggested some draft wording.
Yes.
To say I authorise, to delegate to a discretionary fund manager, and I think that's created quite a stir amongst it in the industry. Where people go, oh, but this LPA doesn't contain that specific wording, therefore do I need to disinvest from all, and a discretionary fund management being pretty broad, in terms of funds or model portfolio services run by DFMs, Octopus Solutions included within that. If there isn't that wording in place, and I know this might be quite hard for you to answer, but if there isn't that wording in place, what do you think advisors should do, or what do you sort of expect the solution to be?
Right, it's a very good, you're right to identify Anna as a hot topic.
Sorry.
I think the reason, no, it's fine. I think the reason why it's a hot topic is that in the last couple of years, as it's become something that's been discussed by the financial services sector and, believe me, by the legal profession, there has always been an underlying the Office of Public Guardian are going to perhaps try and clarify this in some way. There was a suggestion that there might be a test case or something like this. Now, I am not a party to the decision making there, and so I don't know why it hasn't happened. Certainly there was a very strong view that this needs to be clarified by a court decision. As yet it hasn't. Is it going to be? I think it will be, because the momentum hasn't stopped. The issue is still something people keep arguing about, and it comes down to quite a complex issue of law. And we're certainly not today going to expect all these poor financial advisors to listen to a deep, in-depth legal discussion about the laws of agency and delegation, for which I'm sure at the end of this webinar there'll be a big sigh of relief. But the issues come down to, in principle, if you are a power of attorney, someone has delegated to you the decisions. And there is a general principle that you cannot delegate a delegated function. So if I give you the right to make decisions on my behalf, you can't give it to Joe Bloggs to do it. Yeah. Now, in theory, when you're managing a discretionary fund management, and in practice, when you sign up with them, you're saying to them, this is my objective, what I want to achieve. You, discretionary fund managers, make those decisions. So on one interpretation of powers of attorney, you couldn't use a discretionary fund manager because you've got a delegated function and you can't delegate a delegated function. That was that's all I'm doing on law. The way to do that, obviously that's arisen a lot because people have said, oh my goodness, I'm doing this. And look, Granny always used a discretionary fund manager. What do I do now? One of the things that the OPG said, which is a good idea, is they gave some wording and said, if you're setting up an LPA, so we spoke this morning about, should you encourage people to set one up? Yes. And if they haven't got one and you're doing it, then it's really a good idea. In fact, I'd say it's more than a good idea to include that in there, even if at the time they're doing it, they're not necessarily thinking of doing discretionary fund management, because it fetters the discretion of attorneys later, should that be something they need to do in a few years' time. Some solicitors have actively said, I've reviewed our LPAs and we're writing to all the people that haven't got this wording from the OPG to suggest they come in and do a new one. Now, I'm neutral as to whether that's a commercial decision, but what I would say is it's a very good point, isn't it? If you know they haven't, you need to suggest to them that it's not there and tell them what the drawback of it not being there is. The more difficult bit is those people that are arguing that it isn't in there, I've been doing it for a long time, I'm going to go ahead. I think other people have different views about whether you can delegate a delegated function as a legal point. Personally, I think there's some arguments that you can, but equally people who are very well qualified, better qualified than me, would say they aren't. So I would say the jury's out on that. So if you do decide to do that, I can't tell you it's the right thing to do, nor can I say it's the wrong thing to do. But what I would say is, if you're looking at what the overall view of doing of an attorney is to act in the client's best interests, there would be some issues around pulling out of a fund which might give rise to a deficit, depending on if you draw the funds at a certain time, depending on market factors. I have to say here, as you said about risk, I'm not a financial advisor, so I'm not in any way wanting to make judgments about anything about what you should or shouldn't do specifically. But in a generic sense, it may be a bad time for the market. They may also give rise to some kinds of tax liability. So if you're looking at Section 4, trumping the principles of the Mental Capacity Act, the jury's out, there's no legal decision, but that's the dilemma.
How, going back to one of the points about solicitors suggesting, that everyone rewords their LPA, how practical is it for somebody to, aside from any legal costs, how quick or practical is it to change an LPA?
It's quite practical, it's not difficult to do. I mean, the turnaround time, it's like anyone making an LPA, it doesn't happen automatically. But as the OPG has become much, much more efficient, and they had to, because if they're going to facilitate and encourage people to do LPAs online, they've got to have a timeline that's, but even so, it's still several weeks or whatever. So that varies from time to time. It has been months, it can be weeks. So there might be a time delay. It's quite straightforward to do it, but obviously there are cost implications.
Yeah, and I think to your point as well about actually just trying to, I suppose, take a very practical view on it, and a lot of firms we work with just take a risk-based approach and actually look at the parallels in the trustee investment powers, for example, where if I were your attorney and you'd ask me, for example, you had a pot of money, who would be better qualified to manage that for income? I know a little bit about investments, but I suspect a qualified investment manager would be far better in investing in emerging markets for you to provide you with the growth or capital growth or income that you need, rather than me. And so I think it's just that is where it becomes, actually practically speaking, that's where delegation can make sense. A question that we received, actually, which I can probably answer, but I'll sort of share with you. You can talk about it. I can answer on my own question.
That's a good way to do it.
Is with business property relief, because it's an investment, it remains inside someone's estate, and it can be IHT efficient, as we know, after 2 years. And so what we sometimes see is that advisors will typically, depending on the client's situation and their potential need for care and so on, they might make some investment into BPR qualifying investments. They might have done some gifting and other inheritance tax planning too. But with the BPR investment, they know that actually you can sell those shares because it's an investment and it remains within the estate. So if circumstances change, then yes, you could maybe use that to pay for additional care down the line if maybe provisions haven't been as expected. And a question we got was actually, are BPR investments, because they're IHT-able, are they accessible when it comes to care fees provision? And the short answer is yes. Because it's an investment. So, yes, you get your IHT relief, but no, it's not outside of the estate, and therefore it's going to be accessible. But I think that is a huge area where there's a bit of confusion.
I think you're completely right. I think you're so right, because two things. One of them, first of all, is that if you're looking at for inheritance tax planning, there is a benefit. I won't say an advantage because that would be giving an opinion, but there is one of the benefits is that one of the other things you might do is do some lifetime gifting into a trust. Yeah. If you put that into a trust and the trust works, shall we say, so the asset's disregarded, one, you've got to be very careful that you don't need it, and very careful that it would even work if that's what you mean. But the point is, people, when they make gifts, when they do transfers like this, actually don't know what's going to happen in the future. And so one of the things a good advisor, legal or financial, would say is, but of course, once you've done this, you can't take this back unless you break the whole thing. Whereas with the kind of investments you're talking about, there is the flexibility that although you're hoping not to have to need them, if you do need them, you can get them back. And so in the end, it's a decision for every client of what is more important to them. And to be frank, quite often with people, if it's well explained, some of the reasons why people don't do estate planning is because they worried that it's so either or. If I give it in my lifetime, I have to lose access to it. There is a benefit to that, an advantage to that, shall we say, or benefit in that circumstance, because if the need for care was much greater or the costs were greater, whatever, you would be able to access those. And you'd trade against that a negative side, that you wouldn't have waved a magic wand and prevented them even being accessible by the local authority. But I would say here, going back to this again, I've kind of put little commas around the bit about taking assets out of the estate. Whilst that may be something a lot of people want to do, if it's well explained, not everybody does want to do that, Anna, particularly not wealthier clients, because if you take your assets and you remove them from local authority means testing by whatever magic formula you decide to use, and it works, you will be limited in your care and choice that the local authority provision gives you. And for wealthier clients, that's certainly not something they want. And so what they want is to be able to access their funds if they need it, but also to be able to do some inheritance tax planning.
You're absolutely right, and I think if you can, in some ways, I wouldn't sort of say it's fair to say get the best of both worlds, because of course you're taking investment risk, clearly, but I think it's trying to balance out those two quite different, similar objectives, but sort of quite different outcomes potentially. And
I think you're right, and that comes hugely to something that I think you probably would speak to me at some point about, but about recording all this.
Absolutely.
Because the real key point there is it's a one-to-one decision for that individual person, and only they or their attorney looking at this can make that decision. And the only way you can justify those decisions is if they've made an informed decision, and that informed decision means they really must have understood the risks involved in that.
Absolutely.
And if for them the opportunity to not have to be either or, to say, well, I'm hoping I won't need care, I'm hoping the rest of my funds would cover it, but if anything unforeseen happened, I know I've got that flexibility. For that person, that might be the thing that moves them most. And for other people, it might be, well, actually, it's great, but the risk's too high. The point is, it's a matter of choice.
Yeah. And I think you mentioned something when we were talking about for wealthier clients and actually wanting to be in control and have more choice when it comes to care, and therefore wanting to keep the assets in their estate. And I think that sort of circles back to what we were talking about at the beginning around why people aren't doing inheritance tax planning, and why, yes, a lot of advisors are talking to their clients about it, but they're not doing it, or they're not bringing it up with them, or it's quite hard to start that conversation, because when people think inheritance tax planning, they think, I'm giving my money away. And most wealthy clients, or people that we talk to would say, yes, when I'm gone, I want my beneficiaries, my children, my grandchildren, whomever, the cat sanctuary, to get to get as much of my wealth as possible. But when I'm gone, well, I'm here, I want to have access to it. And that's where actually knowing that there are other options, I'm not saying, for example, BPR qualifying investments, so the be-all and end-all, they're not silver bullet of IHT planning, but just knowing that there is an option to at least consider and balance that with other forms of IHT planning, I think therefore does open people's minds a bit more and to start thinking about planning earlier on. But it is hard to start that conversation.
I completely agree. It's hard to start that conversation. Listening to what you're saying, I completely agree with you, Anna. But if you have a client who you can feel their reluctances about control, then it is a good idea to go across the range of options and include those for which that flexibility may be more attractive to them. Because that is absolutely the case. When I did a lot of estate planning, it was true to say that even people that were keen to do it would take advice, would mull it over, would read everything, would have loads of conversations, probably sat around at dinner parties talking about it. But the moment where you have to do it is psychologically very difficult. And that's why people do leave it, sometimes longer than they should. And I think with an ageing population as well, there's another thing which I think the Financial Conduct Authority are looking at closely, which is vulnerability. And there is a real issue that as people age, they feel their vulnerability more than they did when they were younger. And so they start to feel, if control's been really important to them, and for a lot of people that are wealthy, without making a huge, kind of sweeping holistic statement, a lot of people that are wealthy and have had to deal with finances, control is important to them, or at least some element of self-determination. And to feel they're going to give that up at a time when perhaps they are starting to feel their own vulnerability, they feel a bit like life isn't quite as easy as it was. It's very true to say that all people in the health sector will say that as people get older, by 70 they probably have 2, maybe 3, maybe small but related physical difficulties. They're probably all on some kind of medication. Psychologically, that starts to make a person feel vulnerable. And if you introduce at the time as well, and not only now do you feel vulnerable, but we're asking you to give up that one thing you feel you still do control, that can be very hard.
I think that's, you mentioned that about vulnerability, and I think, as you say, as people get older, their decision making changes potentially, or the speed at which their decision making changes. It could be that the way in which they process information, their attitude to risk will change as well. And so that's another area for advisors to have to think about when they are working with older clients. And for most advisors, they'll have an ageing client bank. So it's going to become more and more of a sort of a challenge potentially for them to think about. What sort of training and guidance can advisors get, and should their staff get, around this area of sort of vulnerable clients?
Well, that's a good question. Starting at the top with why I think most organisations should, there is a move by the Financial Conduct Authority to be very concerned about vulnerability. So they did, as you know, the FCA did an ageing population review. They did it from 2015 to 2017. They produced their ageing population result at the end of that, and they subsumed it into the whole aspect they looked at the end of 2017 of consumer outcomes. But basically the FCA were highlighting that they have on their agenda that financial advisors have to be taking into account vulnerability. So I think from that agenda, everybody needs to be looking at something around vulnerability. for people working with older people. I'll give you an example with SOLLA. Where do our members come from? Some of them come in because they can see this is an area, a market area which it's a growth area, and that's good. It's a satisfying area because you really do feel you can make a difference, and they want to get into the older client market. But quite a significant number come because, as you've just said, their population, their own clients are ageing, and so the needs to meet the needs of those clients, never mind bringing in new ones, they have to understand that. So 10 years ago, I'd say there was probably nothing around in financial services, probably, or very little. There's a huge amount now, and SOLLA, I believe we've been a big forerunner in doing that. So we do have a whole range of courses that are available. You can see them on our website. And I would say as well, so do lots of other professional bodies or whatever. People like yourselves offer all sorts of training, specifically around things like powers of attorney, which I think are really important. But the other bit, which I say we do in SOLLA, which I think is a way that more people are needing to look at, is a little bit around behavioural economics. In other words, how older people, how you have to, as an advisor, adjust perhaps your advice process to working with older people. And I think the FCA, when they did their ageing population part, looked at that. And I was lucky enough to sit on their working group on that. So I had a real opportunity to hear a wide range of really experienced people talking about how they incorporate vulnerability into their strategies. But it's very important that you recognise that with that ageing population, there might be behavioural changes and that you might have to make adjustments. So for an example, I think there's a lot said about dementia and about illness that comes, cognitive decline that comes about from, say, an illness. And we're getting much more understanding about dementia, Alzheimer's, about other people making decisions for you. It's really also important to understand that even people that age healthily, that don't have dementia, that don't have any kind of cognitive disability, actually the brain changes. Just like your body does, your brain changes. And the way people arrive at their decision making, the things that matter to them changes. And for financial advisors to start looking at that. So certainly information overload. And here's a challenge, because I'm really sympathetic to financial advisors with the amount of information that by regulatory requirement that you give people. However, anyone dealing with behavioural scientists, dealing with older people, will tell you that the ability to sift through, so what your fluid intelligence will change over time. So the ability to sift through information will change. The more information there is, the harder that is for them. So consider bite-sized chunks. You know, one of the other things is that sometimes with physical problems with older people, it's so straightforward, but just looking at, is the typeface right? Can they read it? Are we sitting in a position, as we didn't even ask this of ourselves, where we can both hear each other effectively, see someone effectively? Those kind of simple things. I was doing a bit of an audit on advisors that say they have the right environment to see clients. So I'll give you an example. I looked at an organisation, they'd had every process in place. It was brilliant. They did say as well they had disabled access so that you could get in to their building, which was great. But it's one of the ones I actually visited. Now, it's brilliant, but it did have a car park that was developed entirely from shingle. Now, if you've ever tried to push a wheelchair across shingle... Indeed, yeah. That isn't ideal, is it?
No.
So, you know, when that was pointed out to them, it's like, I hadn't even thought of that, because we were thinking about things like the doors are wide and, you know, we've got a lift. So advisors in the older client sector have got to take into account that there's vulnerabilities with older people, and there's lots of training out there for it, and some of it is about just alerting them to the ways in which they might have to provide information differently, look at the environment in which they're providing the information differently, to make the experience better for the consumer, for their client. And that also means their client's more likely to be able to make their decisions themselves for longer.
And I think, as you said, that's really important, because it's a terrible assumption to make that if somebody, because they're changing the way they make decisions, if it slightly takes them a little bit longer, just because they need it in a different format, doesn't mean they can't make that decision. No. And the same point about where there's a power of attorney in place as well, it's about that specific decision at that specific point in time. And so people make sweeping statements, I think, which is that they can't make that decision.
Absolutely.
And actually it's about trying to create that environment in which that they can.
You're completely right. I mean, I know that I wouldn't deem to speak exactly for the Alzheimer's Society, but I will do on this occasion and say, you can see their frustration when people say, Advisors, for example, well, she's got Alzheimer's, she can't make decisions for herself. That's not necessarily the case. It's about what decision they can make and at what time. Depending on what kind of, say, dementia you have, it may be that you can make quite a lot of decisions for quite a lot of time, or you might need some help to do it. And that's where, going back to this whole question of powers of attorney come in. When an attorney makes a decision, they are supposed to ask themselves, could the donor still make this decision? Could I do anything to help them to make that first before they go ahead and do it? Now, where someone's clearly lost capacity, in a way that's just an intellectual part of the process, because clearly the person's not going to do it. But for people coming down the range, or with people with fluctuating capacity, it's really important that people don't step in and make decisions when that person could make them themselves.
And from an advisor's perspective on that point, that's where it can get a little bit confusing, I think, for advisors. It's knowing if they feel like someone is losing capacity, but if they feel like someone's losing capacity, but then maybe there isn't an attorney in place, or that the attorney can't yet act, for example, or that the attorney is acting, when they shouldn't be, because actually the donor can make decisions. What can advisors do if they feel, who does make that decision about whether someone does or doesn't have capacity? Is it the advisor's responsibility, or what should they do?
A bit of both. For the attorney, when there's a power of attorney, it's them, in a sense, that has to decide, should I be using this power of attorney?
So it's the attorney's
if the donor has made someone a power of attorney and they still have the capacity, the donor will be telling them that they can do it themselves.
Right.
So if you were sitting there, they might say, I can do this myself. And that tends to also not happen quite so much in an all-around sense, because when you register, with a registry, you explain at the time that as you lose capacity or make that decision, they should get into a rhythm of doing that. If someone hasn't got a power of attorney, I'm very sympathetic to this. If you're a financial advisor or indeed a solicitor, if you're sitting there with someone and you start to feel that somewhere along the line you just don't feel comfortable that they really are understanding what you're saying, that they appear not to have the attention span, they seem to be preoccupied with other things, so you're talking to them about something quite difficult. If they listen, they'll understand, and instead they're stirring their coffee and looking at the pictures. You would be ill-advised to ignore that, because it may well be that they genuinely haven't really taken in what you said, so they're giving themselves a diversion tactic to do that. What do you do? That's really the big question. This is really for an advisor to decide, but what I would say is this. I know you don't want to risk losing your clients, and it's really hard to have this conversation. But financial advisors, one of the skills they have is, or should have, is communication. You need to be ensuring that this person understands what you're saying. So you need to do some reflective speaking to feed back to them, so that you can form a judgment that they do actually understand, or they don't. If they do, that's great. If they don't, then I wouldn't tactfully start saying, I don't think you understand this, but you could be starting to suggest that. Would you like perhaps to review this at another day? It's quite a lot to take in one go. Would you like me to write to you about this? Would you like, while you're here, can I check, is the font size okay with you? Because that's how we'll write to you. What would be your preference? Would you like to have someone with you? Not saying they have to. And an analogy is with the doctor. Quite often older people will take someone to the doctor with them because they'll say, oh, it's so much taking in one go, I just want you to take notes. They're not asking them to make the decision, they're just saying, can you listen? You can offer them that flexibility. If that doesn't work, then tactfully but politely, you're going to have to say, these are really big decisions, and a good way to do it is to say, obviously, if you make this decision, you want it to be effective. You want us to be able to do this. If there's any doubt about that, so to protect ourselves, it might be a good idea to be able to put on record that we've done you've had a capacity assessment, because you know what people are like, they might challenge it. So you make it that it's very collaborative, but one way or the other, you need to have recorded that that they have understood how you've arrived at them understanding, and if they haven't, you really shouldn't be going ahead. If at the end of that you don't, and then the best way is to try and tactfully get to having a capacity assessment done, and record that as well.
And record keeping, which we've talked about a couple of times. Record keeping.
Yes.
That's the last bit I was just going to talk to you about, actually, in terms of, for advisors, this is clearly a huge area, and I think where there is this complexity and potentially some grey areas and a bit of ambiguity, I think, the importance of record keeping for advisors in terms of client meetings. Advisors have asked us in the past, is it appropriate to record a meeting, an audio or video recording? I don't think there's one right or wrong way to do it. As you said, down to what does the client feel comfortable with. But I think the importance of record keeping is key.
I think there's one that we can definitely start with, the one they're not, and that is to do it in any way that's furtive or secretive.
Yes.
So we can rule that out for a start.
Yep.
So covering
that applies generally, I think, in life.
As a general call in life, generally that's called covering yourself.
Yep.
And it's fraught with difficulty, not least of which it wouldn't even be admissible, leaving that aside. Yep. So record keeping, yes, it doesn't have to be as dramatic as recording it all, but that just depends on people's own preference for how they feel comfortable with having got the situation recorded. You definitely do have to have really good records, and I say this not from from a background of law. When people die, for example, and there's nothing like a will for bringing out the family who complain or the people that weren't in it that felt they should have been, very often people that are unhappy with that will challenge the will. And they'll challenge the will on the basis, my mum would never have done that. She loved me. Or my mum wouldn't have done that. Or my brother was there at the time, I'm sure he made her do it. Or I'm sure they didn't explain it to her. Now the poor solicitor who's done that will, that's putting in a way them under scrutiny, isn't it, as well? Did they do that appropriately? I can absolutely tell you that the best defence of all, of duress or anything, is to have had brilliant record taking, because when the court looks at that, all it can look at is what was said at the time. Everything later is a distant memory. The elderly person has died, for example. So I see that in the legal profession, and it's analogous in the financial services sector. You look at it with the police force. When they write notes, they're supposed to write them, as you know, contemporaneously. So it's about write it down at the time, record everything, and importantly, you need to record if other people were present. Yeah. And I think most practices that do a lot of older client work have what are called an older client practice manual. So they'll have set procedures they always do. And one of the things might be to ask yourself as well whether or not you want, you think it's suitable that another person is present. Certainly when you're looking at gifting, if that other person is present there, you'd ask yourself, when you ask the questions, did Mrs. Smith answer? Or did Miss Joe Bloggs, who was with her, answer? Did he prompt her? Note those things at the time. So I think all those kind of things have a real strong record of what was said, who was there. And another thing on that, it is my firm view that no matter what, you should see the client on their own at some point. Yes. Absolutely. Yeah. Even if there's a great relationship between them, even if it appears to go well, you should see the person on their own. In Solicitors for the Elderly, we have this fantastic leaflet, which our members use, which is called Why Am I Standing in the Waiting Room?, which is used to give people that say, look, I'm really sorry, I know you mean well, you've come with your mum, but on this occasion, but just to make sure that everything's, I do need to see her on my own.
That's a really good point. And I think, in some cases, the types of clients and advisors working with, they might have worked with them for 20 years. So it's much easier to judge whether something seems unusual, whether there's maybe some pressure from a family member, and also probably to judge mental capacity and the ability to understand. But a lot of advisors are taking on new clients, maybe clients who've never had financial advice. It's the attorney that's contacting the advisor. And it's the attorney who's saying, oh, my mum's in a care home, she doesn't have mental capacity. And that's where I think it's hugely important that the advisor doesn't assume that the mum is in a care home, or the mum can't make a decision. So, as you say, that's where they should actually meet and insist potentially on meeting with the client or verifying.
I think you're right. I think it's right. And one other thing on that, and I think it's quite important for the kind of advisors who might be listening today, you spoke earlier on about multi-generational advice. And that is the gold standard, really, to be able to work with successive generations, to do succession planning for businesses, to do estate planning, to put it all together. One of the things an advisor wants to do then as well is obviously keep good relations with the next generation. Absolutely. That can be quite tricky when you're going to be asking him or her to go outside the door, implicit in which is that you don't trust them and you think they're trying to do something really untoward with the mother, for example. That's all about positioning. Yeah. And so I know some people would say, oh, I hear what you're saying, but I don't want to do it, so I don't want to offend him. He'll be my client for the next 50 years or something. Mm. And the answer to that is it's how you position it. You need to position it that it's protecting them, because in fact it is. Because if anything were to be challenged, any kind of financial decision where the outcome would have an outcome for the beneficiary, if it were to be challenged, the fact that they were present would automatically put them slightly on the back foot to have to explain that they didn't do anything untoward. So I understand advisors not wanting to ask people to go or not wanting to say what's on their own. But actually, if I were that younger generation, I'd actually be happy to work with an advisor who showed that they really had integrity.
I think that's a good point as well about the multi sort of relationships within a particular family and the importance of engaging with the children or grandchildren or nieces and nephews, whoever's involved. Because I think that's where, again, for advisors who have got a later life client, that client is not going to be their client in 5 or 10 years' time. So what's going to happen to that pot of money as well? Yes. When the children take that on, are they going to still come to that advisor? And actually, we talked a lot about record keeping and about advisors protecting themselves in terms of making sure that should there be a future complaint, they've got the records and so on. But the sort of the commercially attractive side for advisors is about, actually, if you have got a relationship with the beneficiaries, when mum or dad sadly passes away and the wealth passes on to the next generation, that they remain clients. And at Octopus, we see in our inheritance tax service, the average age is about 82. So by the nature of that product, clients are sadly passing away more regularly than a traditional investment product. And we have an estates and probates team now who work with the executors, work with the beneficiaries and try and connect back the advisor to the beneficiaries to kind of understand what it was that they actually inherited in their estate. And it's really interesting because about 50% of the cases, that when they've received that money, they know what was going on, they know the advisor already, and the advisor can retain those assets. But in the other half of cases we talked to, they had no idea that mum or dad had an advisor or who they were. And that advisor had no idea who the beneficiaries were, or they knew on paper but they'd never met them. They were. And sometimes it's not as easy as that. I know it's hard to always want to build a relationship. Some people can be a bit secretive, but definitely for advisors, that commercial benefit of involving the family is hugely important. And again, if you can save them inheritance tax and you've done the right care fees planning for them, that's where the real benefit for advisors can come in as well, to get the next generation engaged as well. Yeah.
And I think you're absolutely right. And just to consolidate that, what I was saying about positioning, I think is really important about financial, protecting the older person, who is in the end your client. If you do that appropriately, actually that builds for those beneficiaries who see that you are genuinely putting their mum or their dad or whoever it is first. That builds a feeling of integrity and trust. And they will see that I would like, I would like my advisor to be that kind of person. You will hear people say later, they dealt really well with my mum. So I think that bit around the awkward bit that sometimes advisors say, well, I don't want to upset them, is about the advisor not seeing it as a way of demonstrating that actually they are good, decent people that want the right thing. And positioned correctly, that will probably build the relationship with the next generation.
I think we've talked about quite a lot of content. We could probably talk for a good few hours, but I'm sure most advisors will not want us to
slipped
that.
Away by now.
Exactly. But I think, I suppose in summary, it is a hugely complex area, but I don't think it's an area that advisors should shy away from.
Absolutely not.
I think there is, as you say, lots of training out there provided by SOLLA and other organisations. I think you've highlighted the importance of making sure an LPA is drafted appropriately, and actually, but if it isn't, the opportunity to change that. We shouldn't assume that people who've got a power of attorney in place can't make their own decisions, and it's about that decision at that particular point in time, about the need to think about all forms of estate planning. We've covered quite a lot of topics, which has hopefully been useful for the listeners today. I suppose in summary, if there's anything else or any other thoughts that you had that you wanted to highlight, or any other training, for example, that you see that SOLLA does, that you think, or SOLLA advisors do, that's really important, then keen to get your thoughts.
Yeah, I think you've summarised that really well, and I hope that everybody has taken the time to listen, because that's really, we appreciate that that's time that, is away from your work, and it has to add value, so I really hope it has. There is a huge range of training out there, and I think the issue is around, you need to feel confident. If you're moving into it, because say your clients are getting older, then you're coming into it bit by bit, and you start meeting things that you haven't met before and you're not sure about. There is masses of training. SOLLA does it, lots of others do it. But the key thing I would say, if you did one thing at all, it should be to have some understanding around powers of attorney, because that's, although you will meet powers of attorney in all across financial advice, you will have a disproportionately larger number if you're working in the older client sector, and if you're working in the wealth management section and higher net worth clients, you will have a disproportionate amount of complexity around making gifts, doing that with inheritance tax planning, etc. And that's an area that advisors can easily upskill. I hate that word, but it is the word to use. And there's lots of there. I know with Octopus we've done some webinars and we've done training.
We have a guide, in fact,
we have a
which
guide
I was
as well. In fact, you're
plug as
quite
well.
right.
Yes, a practical guide
I should have,
to advising older clients about estate planning. Here's one I prepared earlier. Exactly. But as you say, this has got some practical tips and a checklist, for example, with
and vulnerability in it as well.
Absolutely, yes, and the importance of training your staff. If you're seeing clients, some of those points that you talked about, if people haven't been scribbling lots of notes while you've been speaking, there's some really good checklist in here that talks about, if you are meeting with older clients, what are the things to remember, the importance of record keeping, which we've talked about,
a lot.
How to explain certain things, and other kind of soft skills considerations, which I think, as you say, is so important as well.
But they are ones, there's training out there. It's a growing sector, and there is a real need for it. So I'd hate financial advisors to shy away from it because they don't feel they've got the skills yet. If they haven't got skills yet, there's a lot out there to help them to get them.
And there's a huge opportunity for advisors as well, absolutely. Well, I hope that was useful for everybody. And I know we probably they'll have more questions, in which case please do send them in as well. As is often with this case, there's sort of no natural start and end. It is a little bit of a complex area, but we're absolutely here to help, as is the Society of Later Life Advisors. Just another guide I wanted to highlight to you. We've talked a bit about the complexity of advising later life clients and how to start that conversation and helping clients sort of understand what all the options are. We've got a guide to untangling inheritance tax, and that just talks through, in as simple a way as possible, is for some quite complex legislation, the kind of the basics of what are the different options, from gifting, trust planning, business property relief, insurance, that type of thing. Looks at all of them. It's a client-friendly guide. So if you want copies of these, hard copies, or if you want us to email you a PDF, then really happy to do so. A couple of other things to highlight as well. We have an estate planning hub on our website, Grow Your Estate Planning Business, where firstly you'll be able to find the recording of this webinar, I'm sure, afterwards. There's also some other pre-recorded webinars on there, as Tish pointed out, in terms of upskilling, some CPD webinars. If you're not familiar with inheritance tax planning, or it's an area you feel a bit rusty on, then by all means do go on there and watch that webinar. There's some really useful guides and white papers too, for example, on the residence nil rate band, some tips for having estate planning conversations with clients too, a residence nil rate band calculator, a gifting calculator, as much as we can think of there to help you. But if you've also got feedback on other things that you'd like to see, then please do let us know as well. We'd love to get your feedback. So thank you very much for listening. Thank you very much, Tish.
Thank you for inviting me.
And we hope to see you at another webinar soon. Thank you.